the evolution.
I'll do that.
And I think that
this is why I'm trying to keep it short. I'll just highlight what I'm saying. Just for a minute, if I can trouble your lordships only with of this volume, page 185. This is the first schedule. The lordships can see that. It's marked. It's the first schedule to the Government of India Act. And in this, my lords, entries 4, 8, 18 and 20. Your lordship may note that. Entry 4, for example, I'll just read to your lordships. To each governor's province, chief commissioner's province and community specified in the first column of division 1 of the table, there shall be allotted the number of seats specified in the second column opposite to that province or community, and of the seats so allotted to a governor's province or a chief commissioner's province, the number.
Was the expression scheduled caste defined in the
It is defined. It is defined in 26. Yeah, but I'll just 4, 8, 18, 20 refers to scheduled castes.
Yeah.
And 26 defines scheduled castes. So just it's the exact same definition that you find now in the Constitution of India. 26. Can they go down? Can you scroll down? 26. That's at page 189, PDF 189, the middle of 189. Yes, the scheduled caste means such castes, races or tribes or parts of or groups within castes, races or tribes, being castes, races, tribes, parts or groups which appear to His Majesty in council to correspond to the classes of persons formerly known as the depressed classes, as His Majesty in council may specify. So this is copy pasted effectively and put in the Constitution. Immediately after this is the scheduled caste order of 1936 by the King in Council, which is at page 253. It's very interesting. The previous year, 1935, Government of India Act is by George V. This is by Edward, who abdicated, as your lordships remember, because of that. So in the 1 year that he was king, page 253, this is issued, first paragraph, page 253, whereas by certain provisions in the first, fifth and sixth schedules to the Government of India Act, His Majesty in Council is empowered to specify the caste, race or tribes or parts of the groups within caste, race or tribe, which are to be treated as the scheduled castes for the purpose of those schedules. And it's not only schedule 1, but other schedules as well, as you'll find from para 2 of this in the middle of the page, subject to the provisions of the order for the purpose of so-and-so schedules. These are the ones who will be specified. Para 3 is interesting. It says, notwithstanding anything in the last preceding paragraph, no Indian Christian shall be deemed to be a member of the scheduled caste. No, in Bengal, no person who professes Buddhism or a tribal religion shall be deemed to be a member of the scheduled caste. This is after the partition of Bengal.
Yes.
And next page onwards are the castes. So these are the castes, tribes, all of them, state-wise, as per those states, Madras, etc. Now, this in its entirety, this goes on for several pages more. This in its entirety, community-wise, was what was replicated in the presidential order of 1950. The presidential order had to be amended a few times every time we had a reorganization of states, because it was unclear whether that community will remain an SC for that partitioned state or not. So they did. Every time there was a reorganization in 56, 59, they did actually amend the presidential order of 1950. I'm quickly coming to my second limb. This is to give your lordships context and to say that these are the groups. Therefore, at a later stage, when you come to enabling provisions, when you decide to give those communities, if some of those communities have been, say, for 16, adequately represented, then it is incumbent on the state not to repetitively give them, who are adequately represented, that benefit. I think that point has already been made repeatedly. Second, I'm just handing this over. It's there in this volume as well. It's there in the volume, yeah? Just take 7 copies. This, my lords, is something I had submitted in the EWS reservation case, the 5 judges, just which has been included in the Janhit Abhiyan judgment, in fact. It's a chart showing reservation provisions under the Constitution. All the provisions I have, which are dealing with this, just to help address your lordships on. It's in this also. It's at page 805 of this volume. It's at page 805, but I'm just addressing it from here, if I may. This is to show the provisions, my lords, which govern each of these communities. The central one, the red one, is SC/STs. The one outside that is SC/BC, OBCs. and the one at the outermost is EWS. We can ignore EWS for the time being. SC/ST, the definition provisions are there, then the special provisions are there. Now, why we have color coded it separately is for the parameter that has to be applied. The parameter that has to be applied for the scheduled castes and scheduled tribes with reference to 15 and 16 is historic untouchability. Because I think there has been a general sense that social and educational backwardness is the determinant for being an SC/ST. That's not true. For being an SC/ST, it is about its historical backwardness and it's a constitutional atonement for those years of discrimination. So for determining who the scheduled castes are, and this is what even the 5 judges decision in Mari Chandrasekhar says. Specific paragraph I'll give you, it's para 9 of Mari. Mari is, I'm sorry, it's not part of this volume, but the paragraph is extracted. It says that it's the historic untouchability which is for the determination of SCs. Social and educational backwardness, which is defined in the Constitution, in Article 366, says for the purposes of this Constitution, socially and educationally backward are those who are determined by way of the list which the President provides. But that came in by way of an amendment, that definition, because after the Indira Sawhney judgment, the Indira Sawhney judgment gave one direction to the government. It said that please ensure that you set up a national commission for the backward classes, and they set up a national commission. There was a National Commission of Backward Classes Act. Subsequently, when the Constitution came to be amended, that National Commission was taken and put on a constitutional plane, from statutory to constitutional. And therefore, the definition had to be given of who are socially and educationally backward classes. Now, there has been a little bit of debate in the past whether socially and educationally backward classes is the phrase used in 15. It's not used in 16. In 16, you say backward classes, which is why you get the O in the OBC. You have SCs, STs taken anyway to be backward classes for purpose of 16. Other backward classes are those outside of that. Are they the same as the SCBCs? The Constitution seems to suggest to us, courtesy all these amendments that have come, that they're perhaps the same. We don't have a 4th list of OBCs. We just have the SCBC list. That's the one that's adopted. But for determining the scheduled castes and scheduled tribes, it's historic discrimination. So that pink one shows that that's historic untouchability. Now, the reason why I put the blue ones, your lordships will see,
the political backward.
Political backward.
Political reservation.
So in municipalities and panchayats where you have these provisions, as well as in the Lok Sabha and the legislature, these are the political backwardness determinations that have to be made. The third, of course, are the social and educational backwardness, which are in yellow. Now, one small distinction, I think, which is essential for answering the question that has been referred to your lordships is simply this, that the idea in the Constitution at the time the Constitution came in, the SC/ST communities had only one provision of reservation to them, which are the ones in 330 and 332, nothing else. As a provision of reservation available to that community, it was only in the legislatures and parliament. Subsequently, when enabling provisions were activated from the outset, from Champakam and Venkatraman, both decided in 1950, or one on 15 and the other on 16, there was an activation of that. Even though the GO was prior to the Constitution, there was an activation of 15 and 16. Once you activate 15 and 16, does the state not have the right to say that, look, your list which the president has made, that remains intact. I'm not trifling with it. But for my purposes, where 15 and 16 gives me the right to make a measure, yes, I believe that these communities need to be favored. Now, whether the choice of those communities by me is right or wrong will be determined based on reports, based on other data. The Indira Sawhney judgment says use the barium chemicals, yes, measures to determine that. But that list remains intact for the purposes of the political representation. So for municipalities, panchayats, legislature, and Lok Sabha, I can't touch it. The state has absolutely no role to play in that. That remains. I hope I'm making myself clear. So that distinction is necessary. This entire debate here is really only about 15 and 16. Because the definitions both in 340, 342, as well as in 341, 42, as well as in 366, make it clear for the purposes of this constitution. So the SC/ST determination or definition for the purposes of this constitution encompasses the mandatory political representation for which the state has no role to play at all. It can't interfere in any way. And where the state has a role to play. It's only in that where the state has a role to play under 15 and 16 that it is the entitlement. In fact, it's a constitutional obligation of the state to make such determinations. So this chart is for that purpose.
We've got the point. Should be now closed.
The last thing is to address those questions. One more. There's a judgment of your lordships, which is in this compilation at page 353, my lords. This is a small concept which may be relevant. This is a judgment of my lord, the Chief Justice and Justice Shah in 2021. This is at page 353.
Yes.
Patan Jamal Wali. It was dealing with the outrage, the rape of an SC/ST lady who was also blind. Now, two paragraphs, just see para 17 at page 372, internal 372, para 17.
Yes.
This principle of intersectionality, I comment to this bench. Intersectionality can be defined as a form of oppression that arises out of a combination of various oppressions, which together produce something unique and distinct from any one form of discrimination standing alone. While the model of intersectionality was initially developed to highlight the experiences of African American women, there is a growing recognition that an intersectional lens is useful for addressing the specific set of lived experience of those individuals who have faced violence and discrimination on multiple grounds. A single axis approach to violence and discrimination renders invisible such minority experiences within a broader group, since it formulates identity as totemic and homogeneous, which is precisely what CJI has done. Each of these communities have lived experiences which are distinct from each other. Even in Indra Sani, I'll give you a lot of the paragraph, there is a acceptance. Justice Krishna and Anam Thomas says that even within the scheduled castes, they're not all alike. They're all very, very different. They have different experiences. But I won't read the rest of the paragraph, but I believe this paragraph and para 795 of Indra Sani. Both of these, your lordships may just consider. Now, quickly, I'll just address the questions that came yesterday. Justice Nath had asked a question that once people have achieved to a certain extent, wouldn't you remove them from the list? That's not a call for the state to take for two reasons. One, that they don't have the power, that's for the president to do on recommendations by the state. But when they've reached that level, you have to see that they've reached that level not only in my domain of 15-16, which is education and employment, and everything else socially.
Why can't the state take that call?
State no, because the removal
from the
state
is deciding to allocate extra percentage of reservation for specific communities within that scheduled caste group. It can say that these are already adequately represented. They don't require any reservation. Why not?
No. So the problem
the
is
state has to implement
the under 15 and 16. It becomes implicit. Because the state, when it's giving its reservation, says, I choose these 10 communities and I give it to them. So the others get excluded.
What is backward class?
Yes.
You can always say this backward class does not require any further.
I don't think the negative declaration is necessary when they positively.
Not the parliament exercise.
So if they give the entire extent of the reservation,
they can
so state 10 communities.
Gain advantage of 15.4 or any other provision.
No.
Or 330 or whatever.
Yes.
But for 16.4 is concerned, they can always exclude.
Yes, so that comes to the second question, my lord. The Chief Justice posed to the Advocate General yesterday. If there are only two communities and you decide, can you give entire 100% of the reservation to them? My answer is different. My answer is yes, you can. Because the idea of this constitution is that at some point you will, because you'll reduce from your 100 caste groups. Hopefully, we are moving forward as a nation. If you keep moving forward as a nation, some of these communities will get adequately represented, will move forward. So from 100, you'll come to 50, 40, 30, at some point you'll come to 2. And you'll say, look, these two are so terribly ravaged that there is no question that I'm going to give my 100% of that reservation available to me to them. Both the quantum, that is percentage, as well as the number of communities is in the state's hand. So the state doesn't have to give 40%, state can give 4% reservation and say the entire 4% will go to 2 communities. So that's to answer the second question, Maloj, which I believe that would be the correct answer, the consistent answer, because this constitution and its interpretation not for today. When we have 7 judges going into this, 20 years from now, we may hopefully reach a stage where we will have only 2 communities and we'll be able to take care of them also. And this, yesterday, Justice Gawai had a question about the creamy layer application in the SCSTs. Now, Nagraj said so, saying that 16.4A, 16.4B as a constitutional challenge can be sustained only if it has these controls: efficiency under 335, administration, the adequacy, and creamy layer. In Jardinale, when that question had to be referred to a larger bench, they said we're not referring to a larger bench, but this backwardness determination for SCSTs is not necessary, it's implicit, removed that, kept the other 3 intact, reiterating the fact that creamy layer applies to SCSTs. So creamy layer applies to SCSTs because it's an individual removal. But in practice, on the ground, there has been no office memorandum that I know of, the state may assist, which they have issued for the creamy layer removal among SCSTs. They have one old 1992 office memorandum which removes the creamy layer for the backward classes, which is detailed, which has, politicians, members of parliament, etc. Then income criteria also.
Shankana will close it here.
I'm grateful, Madam. I'm very grateful.
Should we hear Mr. Venugopal first? That was what.
Yes.
Mr. Venugopal,
They've taken.
are you online?
Yes, I'm on the line.
Yes, Mr. Venugopal.
Great, please, Lordships. But much has been covered. And my
Manoj, sir, may I take your leave? I'm sorry.
Yes, sir.
I'm appearing, Lords, for the Madiga Reservation Porata Samiti. And it's item number 701.22. And it's writ petition 562 of 2022.
You are for the intervener,
No, my lords, I am for the petitioner.
for the petitioner.
Yes, I think.
But only
Ms.
Mr.
Shraddha is-
was the
Ms. Shraddha is for the intervener.
intervener, rest are the petitioners.
No, my lord, so far as this is concerned, I had appeared before the 5 judges in the Andhra Pradesh High Court in Chennai. They had upheld the subcategorization of 61 scheduled castes into 4 divisions based upon their advancement over the years. And they had given, my lords, 7% to the weakest among the weak, 6%, my lords, of the jobs and educational institutions, seats, to, my lords, another group, and to the best, to the highest among them, 1%, 1%. This was upheld on the basis of categorization was permissible. Chennai, my lords, reversed it and said that the whole of them being a homogeneous group, this cannot be done. Now, the basis of, my lords, the subcategorization was an elaborate 200-page, my lords, investigative, my lords, report of Justice Ramachandra Raju. And the judge, my lords, after enumerating this, found that there was vast disparities between the different groups in the 61, my lords, subcastes, some of them being, my lords, workers in leather, the scavenging, and, my lords, nomadic, and so on, who had been excluded to a very great extent, so that the fruits, my lords, of reservation had been taken over by the more advanced ones among, my lords, the entire group of 61. And that is the basis on which, based on this comparative advancement, my lord, of the groups, he had grouped it into 61 into 4 groups and had given varied, my lord, representation. Now, this is, my lord, what was held by Chennai, and, my lords, was reversed by the Supreme Court of India. Now, my submission to your lordships is this. Article 14 of the Constitution, my lord, is a golden thread which runs right through the entire provisions of the Constitution. At the very inception of the Constitution, the founding fathers had examined the disabilities of various groups and had provided in the original constitution itself for affirmative action for the purpose of their upliftment. And therefore, my lord, if your lordships would be pleased to take my written submissions, which is a short 10 pages.
1G.
It is
Where would we find them? Where will we find them, Mr. Venugopal?
volume 1, capital G, my lord.
Yes. Just a
Your
second.
lordships will find.
Give us just a moment so that all of us can access it.
One G.
Yes, it's page 1.
Your lordships will find, if the lordships would be pleased to go to page 5. The various steps taken, my lords, by the founding fathers themselves to ensure that unequals are treated equally with the rest of their category to which they belong. And at the bottom in paragraph, my lords, 11 of page 5, your lordships will find article 15.3, special provision for women and children. Your lordships have got it, my lords. Para 11. I hope your lordships have it. Para 11, my lords, at page 5.
Yes, Mr. Venugopal.
And then para 12, 15.4, that is the backward classes. Then it goes on like that. 15.5, scheduled caste, scheduled tribes, admission to private institutions. Then economically weaker sections, 15.6, which your lordships upheld, 10%, my lord, in addition to the 50%, and 15.6b, 16.4, 16.4a, 16.4b, 16.6, 17, untouchability, and 18, which is, my lords, against against titles to citizens, which your lordship has held in one of the judgments, Indian young lawyers, that some people are being placed above the others, and this cannot be permissible, and that is why. Therefore, so far as, my lords, the benefits are concerned, it is in regard to the state has given benefits socially, educationally, in employment, and politically as well. And your lordships will find that politically, it is in article, my lord, when the panchayats were introduced, in para 22, that is seats for scheduled castes, scheduled tribes in panchayats. Similarly, my lords, in regard to, my lords, the municipalities, then the benefit, my lords, to women, where they are given 1/3 of the total seats, rotation of the chairman, where the women will be given, that also. Now, this is, my lords, the broad basis on which the Constitution had approached, my lords, these inequalities which have been prevailing in the population, my lords, of this country. Thereafter, my lords, they found during the course of the working of the Constitution that there were certain, my lords, classes which stood again deprived of what would be, my lords, an equal treatment under the Constitution. And therefore, my lord, amendments were made. And that is how, my lords, so far as the benefits to scheduled caste, scheduled tribes, to entry to, my lords, the educational institutions, including, my lord, private institutions, was provided for. Economically weaker sections were given 10%, irrespective of religion, caste, creed, etc. Now, similarly, very many other amendments. Now, in this background, I would request your lordships to go to Article 28.2 of the Constitution.
38.2, right? 38.2.
38.2. And this, I say, is a fulcrum on which the entirety of, my lord, the problem is to be approached. 38.2 is, my lord, so far as this is concerned, in the directive principles, the state shall in particular strive to minimize the inequalities in income and endeavor to eliminate inequalities in status, facilities, and opportunities, not only amongst individuals, but also amongst groups of people residing in different areas or engaged in different vocations. Now, so far as this is concerned, it was brought in by an amendment of 1978. Now, this would say that so far as inequalities are concerned, they have to be minimized, not only, my lords, that in regard to status, facilities, and opportunities, not only among groups, but also among individuals. And if your lordship should turn to Article 37, application of the principles contained in this part, the provisions contained in this part shall not be enforceable by any court, but the principles therein had laid down are nevertheless fundamental to the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Therefore, my lords, 38(2) is fundamental to the governance of the country, and it shall be the duty of the state to apply these principles in making laws. And this is exactly what the state of Andhra Pradesh has done. And therefore, my lords, the question is whether 341 should not be read along with Article, my lords, 382. There are a number of judgments, my lords, which say that so far as directive principles are concerned, they should be read along with, my lords, the fundamental rights, along with the other provisions of the Constitution.
Right from Keshavanand Bharti.
Yes, right from Keshavanand Bharti. And my lord, Unnikrishnan versus, my lords, Unnikrishnan versus State of Andhra Pradesh, that is Jivan Reddy's judgment, 1993, Volume 1, Supreme Court Cases, 648. 645. Unnikrishnan versus State of Andhra Pradesh. And this exactly. From Keshavanand Bharati, Justice Chandrchud at para 161 is extracted. As I look at the provisions of part 3 and 4, I feel no doubt that the basic object of conferring freedoms on individuals in the ultimate achievement of the ideal set out in part 4. May I say that the directive principles of state policy should not be permitted to become a mere rope of sand. If the state fails to create conditions in which the fundamental freedoms could be enjoyed by all, the freedom of the few will be at the mercy of the many, and then all freedoms will vanish. My lord, similarly, there are a number of judgments which, my lord, would require the harmonizing between directive principles, my lord, and the provisions of the Constitution. Therefore, my lord, the golden thread which runs is not only, my lord, that Article 14, that all persons should be treated equally, but not in that unequals have to be treated also equally, and they'll have to be equalized. And if your lordships will take my written submissions, there is an extract, my lords, which brings this out very vividly. And that, my lord, is Mari Chandrasekhar Rao, referred to in other contexts. But if your lordships will be pleased to turn to page 4, para 9 of my written submissions. My lord, the extract, if your lordships will skip the first 10 lines and come to those who are unequal in fact. I hope your lordships have that. After 10 lines from the top. Equality, which must cover every process of equalization. Or shall I read it from the top of
That's
the,
fine. Those, we got it, actually. That's the correct extract. Those who are unequal in fact.
yes, yes. And later, those who are unequal, in fact, cannot be treated by identical standards. That there may be equality in law, but that may be equality in law, but it would certainly not be real equality. Existence of equality of opportunity depends not merely on the absence of disabilities, but on presence of abilities. It is not simply a matter of legal equality. De jure equality must ultimately find its raison d'etre in de facto equality. The state must therefore resort to compensatory state action for the purpose of making people who are factually unequal in their wealth, education, and social environment equal in specified areas. It is necessary to take into account de facto inequalities which exist in the society and to take affirmative action by way of giving preference and reservation to the socially and economically disadvantaged persons or inflicting handicaps on those more advantageously placed in order to bring about real equality. Such affirmative action, though apparently discriminatory, is calculated to produce equality on a broader basis by eliminating de facto inequalities and placing the weaker sections of the community in a footing of equality with a stronger and more powerful section, so that each member of the community, whatever is his birth, occupation, and social position, may enjoy equal opportunity of using to the full his natural endowments of physique, of character, and of intelligence. Now, my lord, so far as this is concerned, your lordship should note that the result of not, my lord, making a subcategorization would be that those who are already more advanced than, my lord, the weakest of the weak, which is a phrase which has been used, my lords, by Justice Krishna here, the weakest of the weak will fall to the ground, and those who are more advanced will take the lion's share, so that this reservation is meaningless and has no effect whatsoever in neutralizing the disadvantages which were sought to be cured by, my lord, the reservation. Now, in this connection, my lord, the words of Justice Krishna here in N.M. Thomas has been extracted at page 9 of my written submissions.
Yes.
And your lordship should be pleased to say at page 9, para 28, the extract from State of Kerala versus N.M. Thomas, page 363 of the judgment, para 124, innovations in administrative strategy to help the really untouched, most backward classes also emerge from such social legal studies and audit exercises of dispassionately made. In fact, research conducted by A.N. Sinha Institute has revealed a dual society among Harijans, a tiny elite gobbling up the benefits and darker layers sleeping distances away from the special concessions. Therefore, my lord, the Harijans are, my lord, the most backward classes among the scheduled castes, a dual society among Harijans, a tiny elite gobbling up the benefits, and the darker layers sleeping distances away from the special concessions. And that is what, my lord, the state of Andhra Pradesh sought to do, which was reversed, my lords, by the by the Supreme Court of India. My lords, your lordship will find the citation at the bottom of that page of Jarnail Singh versus Lakshmi Narayan Gupta, 2018 10 SCC 396. This is a 5 judges bench presided over by Justice Rohinton. And there, my lords, I had argued as Attorney General that E.V. Chinnaya would stand in the way of the principle of the creamy layer, which was upheld for OBCs in the Indira Sani judgment from being applied to scheduled castes. And therefore, since they are only one homogeneous class, you can't subdivide it and remove some of them. Now that was rejected, and the same entire judgment focuses on what was held in N. Thomas. And following that, their lordships held that so far as the creamy layer is concerned, they have to be excluded even from the category of scheduled castes. The result of this is that a constitution bench of this honorable court has already taken the first step forward by dissenting from Chinnaya to the extent that they have said that a subclassification can be made.
Yes.
I may mention, my lords, that after the judgment in Chinnaya delivered by the Supreme Court of India, the government of India, Union of India, wanted the whole issue of subclassification to be, give me that one. The entire issue of subclassification to be gone into by, my lords, the committee, and for which, my lords, Justice Usha Mehra was appointed then by the central government, and which constituted a national commission to examine the issue of subcategorization of scheduled castes in Andhra Pradesh with Justice Usha Mehra as chairperson. This was, my lords, on 16th of November 2006. And the judgment in Chinnaya's case by the Supreme Court was on the 5th of November 2004. Now, Justice Usha Mehra went into the issue elaborately, and her report is at page 345 and goes on to 506. And finally, my lords, where do you find it?
Volume 3A.
It is in volume 3, capital A, my lords.
Page 446.
At page 504.
446.
At page 446.
This page 446. It begins at 285.
It begins at 285, my lords, in your lordships.
Page 446. Three.
No, what is this?
444.
And if your lordship should be pleased to go to page 44.
444.
444. At 33.
Volume 3A, page 444. Volume 3A, page 444.
Volume 3A,
page 444.
page 444.
Actually, our PDF, page 447.
Paragraph 23.
At 33 minutes. Repeat it.
Page 444. of
Volume 3A, page 444 minutes. Is para 33.
This is for subcategorization.
The analysis of data. Your lordship about it?
Mr. Venugopal, we read that actually. We've seen that.
Yes. Para
Anything
33.
else? Anything else, Mr. Venugopal?
Yes,
Or-
no, I am closing with this. Please see, my lord,
46.
page 446,
Yes.
para 37. The commission thus recommends that Article 341 of the Constitution of India be amended and clause 3 thereof may be added as under 341 clause
A
3.
clarificatory amendment, actually.
Yes.
A clarificatory
By
amendment.
law provide for subcategorization,
It was eventually never.
subcategorization of caste so and so within any caste, race or tribe.
Your argument would be that even in the absence of such an enabling provision, the power is always there in the state.
Well, that is what I had relied strongly on Article 38(2), which mandated that your lordships would ensure, my lords, that even individuals who are oppressed or suffer from disabilities, as against their similarly placed persons, should be given, my lord, equal treatment. Therefore, CJI, in saying that it is homogeneous, it can't be broken up. It can't be the weakest of the weak. We'll have to suffer total deprivation so that whatever benefits are being given really is a rope of sand, as Chief Justice Chandrchud delivered it. That I submit has to be neutralized.
Thank you very much. Thank you, Mr. Venugopal. Mr. Attorney General, would you like to open? Yes.
Volume 1K, I think, is my written submissions. I'll quickly read. There are only a couple of paragraphs in Adam Thomas and Chennai, which I may like to draw your lots of attention later.
Volume 1A, right?
1K.
That has not come.
Achha.
It is on the screen.
To go to?
And the Lords have that. Volume
Yes,
1K.
we've got it on the screen, yeah.
Let me quickly take your lots of
And after all of you will also have learned attorney submissions on your
It will be
screens there.
shared with all,
on the screen before you got it.
Well, the field assigned to Article 341 and 342 and the Equality Charter contained in Articles 14 to 16 are distinct. The domain of Article 341 and 342 is confined only to the identification and enumeration of scheduled castes and scheduled tribes for the purposes of the Constitution. What shall be done to effectuate the purpose of the Constitution is not a matter that will fall under the domain of Article 341 and 342. Notification in Article 341 and 342 is the foundation by devising provisions of advancement with the meaning of Article 15(4) and equality of opportunity and provisions for reservations with the meaning of Article 16(4). That is why Article 341 and 342 talk about specification of castes, race, tribes, or parts of groups within castes for the purpose of the Constitution. This means all purposes of the Constitution in relation to scheduled castes and scheduled tribes. Except where there are express constraints, no dissonance between two constitutional provisions should be either suggested or accepted. Therefore, Article 341 is not to be seen as a limitation or a constraint in what can be done or what needs to be done under the Equality Charter of the Constitution, Articles 14 to 16. The dynamics of equality of opportunity and advancement measures will lie in the domain of Articles 14 to 16 and may not be controlled by the mere enumeration authority given under Article 341, 342. The spread of equality of opportunity and the distribution of equality measures are essentially matters that will be addressed by the state and not by the president. The E.V. Chinnaya is premised on the understanding that all the castes and tribes once notified constitute a homogeneous class, except the fact that disparate social groups designated as castes or tribes are described as scheduled, there is no homogeneity amidst them in a sociological sense. Mere clubbing of distinct castes or tribes by itself will not render them homogeneous. As long as amidst these castes or tribes, there is no uniformity of status, position, or social attainment, there can be no homogeneity. They continue to be distinct social groups or sections of the community. Each one of them constitute distinct segments deserving distinct constitutional treatments. The homogeneity, if any, compared with the non-scheduled section of the community cannot be of any consequence. The distinct constitutional treatments will always remain subject to be addressed under the Equality Charter of the Constitution, Articles 14 and 16. The constitutional treatments that the state may devise to address the concerns of one or more of the enumerated scheduled caste tribes will always depend upon a relevant inquiry on the need and expedition required. The fact that parts of or groups within castes, race, or tribes can also be notified is an indication that the enumeration itself will be based on the connection between enumeration and the purposes of the Constitution. The question, however, as to whether such measures of advancement under Articles 15 and 16 constitute a fair spread of measures of advancement and inter se not discriminatory will be an independent inquiry entirely unconnected with Articles 341 and 342. The obligation on the part of the state to ensure fair and not discriminatory availability of the measures of advancement will always be tested on relevant grounds. It is also expected that the state will act fairly in this regard, will not be partisan, and will not arbitrarily exclude anyone of the enumerated list from the fruits of advancement measures. The power given to the Parliament under Article 341(2) is also confined to the domain of enumeration, and the authority to include in or exclude from the list notified cannot be equated to the power of the state under the Equality Charter of Articles 14 and 16 of the Constitution of India. The Constituent Assembly debates in Article 16(4) show that the framers decidedly use the expression backward classes in plural to comprehend all social groups, including scheduled castes, which can be considered backward on certain common criteria and aspects. The 9th decision in Indira Sani has elucidated its understanding. No doubt can now be raised as to the comprehensiveness and inclusiveness of the expression. To the extent discussed above, it can be said that Ivichinaya has frozen all state authority or authority of the states under Articles 14 to 16 of the Constitution. Whether it is in tune with the constitutional dynamics is a question that deserves to be answered. Ivichinaya does not answer many questions raised above. It is built on the premise that all enumerated castes and tribes can and must collectively enjoy the benefits of reservation, regardless of inter se inequalities, and that any subdivision will dilute collective identity and rob the fruits of collective emancipation. This broad statement has no demonstrable truth in empirical terms and is certainly not supported in the judgment itself. The Ivichinaya holding that homogeneity of thoughts in the state of Kerala is open to question. I don't propose a lot of reading several paragraphs in it. I'll just point out 2 or 3 paragraphs of Justice Thomas and Justice Krishnaya in a short while. Articles 14 to 16 constitute a triumvirate of citizens' rights and state obligation. They've been conceived as the Equality and Social Justice Charter, guaranteeing both right towards emancipation from social, educational, and economic backwardness, and non-discrimination all walks of life and state transactions. The state is under a corresponding obligation to devise measures and methods, fashion policies and tools to regard, promote, and protect these rights. The enabling nature of Articles 15 and 16 are instead of duty coupled with power. Any undue limitation on both duty and power in the context of these provisions will be constitutionally suspect. The court has delineated several facets of these rights and also declared the interplay between these rights. The equality rights in Article 14 and equal opportunity rights in 15 to 16 have mutually reinforcing facets. The evolving dimensions of these rights, in consonance with changing social and economic aspects, have been carefully crafted over a period of time, both by legislations and judicial pronouncements. The obligation of the state and the states to undertake emancipation of the deprived and weaker sections of the community, the obligation to eradicate inequalities in status and wealth, are complex obligations involving redistribution and reallocation of resources and opportunities, and equitable access to all public and social goods. Education, health, and public employment are all public goods of immense value, facilitating citizen participation in the affairs of the state on an informed and equal basis. The states will therefore always need the freedom to carry out informed experiments without being fettered by undue or disproportionate claims. There are no and cannot be any textbook answers or precedents of perennial value and relevance which can guide the state or the states as regards the roads to be traveled or measures to be taken to promote fundamental rights. The code too will bear the social dynamics in mind and be careful not to chain the state or clamp its hands while interpreting constitutional provisions. Rule of law also demands that the state is able to harmonize and balance several competing claims and interests. I'll just take a couple of paragraphs in A.N.M. Thomas.
Just give us the paragraphs, Mr. We'll have a look at them because those have been read out.
No, you.
Give us the volume and page, that's all.
A.N.M. Thomas, volume 5.
Volume 5. Which paras?
Paragraphs 53 and 54. You'll not just turn to PDF page 26. I just probably read it from the head note to give those references.
53 and 54 and then?
This is Matthew's judgment.
Right.
At PDF page 26. There are two paragraphs referred to there.
And?
Paragraph 53 and 54 bracketed together.
Anything more? Which other para?
A.N.M. Thomas has been read to us many times.
Paragraphs 53 and 54. This PDF page 53 is a PDF page or 57. Paragraph 53.
Correct? Yes. Paragraph 53 and 54.
57. Look at paragraph 53.
And 54.
Para 53, para 54.
Yes.
Proportional equality.
That's right. Formal equality.
Formal equality, proportional equality.
Is the third line, but men are not equal in all respects. The claim for equality is in fact a protest against unjust, undeserved, and unjustified inequalities. So going a little down in the same paragraph, last line, we therefore have to resort to some sort of proportionate equality in many spheres to achieve justice. Then the next paragraph, the principle of proportional equality is attained when an equal so and so. This will raise the baffling question, equal and unequal in what? The principle of proportional equality therefore involves in appeal to some criteria in terms of which differential treatment is justified.
There are various terms used in the various judgments in
Yes.
That's right.
in A.N.M. Thomas. It has also been decided as a compensatory discrimination.
That's right. Back to also paragraphs 81 and 82. Let me make a note of that. 81, 82, again, Justice Thomas' judgment.
82.
Yeah, 82 now.
Video page 65.
Yes. This has already been argued, Mr. AG.
Yes.
Yes.
You have made a note in your.
Then paragraph 141 of the Krishnaya judgment at PDF page 86.
Thank you, Mr. Attorney General. Thank you so much.
Yeah, the paragraph begins at the basic question.
Yes, we'll have a look at it, Mr. Attorney. Thank you so much.
That's right.
Anybody else now who would like to, Mr. Solicitor is here?
In Chinaya, paragraph 113 of Justice Sinha judgment, just kindly look at that.
Yes.
This is PDF page, volume 5, page 815.
Sinha J, paragraph
113.
page.
PDF page 819.
PDF page 8. We'll have a look at it, Mr. Attorney. We'll have a
PDF page. Just look at the paragraph. The power of the state legislature to decide as regards grant or benefit of reservation so and so is not in dispute.
Yes.
Furthermore, not in dispute that if such a decision is made, the state can also lay down a legislative policy as regards extent of reservation to be made for different members of the backward class, including scheduled caste. But it cannot take away the state benefit on the premise that one or the other group among members of so and so has advanced, and thus is not entitled to the entire benefit reservation. That begs the question.
Thank you, Mr.
That's right.
Thank you, Mr.
Please,
Mr. Solicitor.
I'll not take more than 10 minutes, my lord. I'll bear in mind the distinction between a person, my lord, who has something to say and a person who has to say something. My lord, it is very ably argued by, my lord, all my predecessors, my lord, and especially the learned Advocate General. My lord, please take my volume 1I. It's a 15-page note. I'm not going to read the entire.
It has come on the screen.
Yes.
It has
It is there, my lord. Your lordship would find it at one.
It is
It's here.
here on the
Sorry.
screen, yes.
My lord, what I have done is, my lord, I have given a history which I am again not going to place before your lordships
Yes.
as to how this developed. But the most relevant part is, slowly and gradually your lordships on the judicial side has started taking note of the fact that there needs to be some rationing.
Right.
At the outset, I say, my lord, on behalf of the central government, my lord, it is not my submission about the reservation. Reservation as a policy, the central government is committed to. My written submissions, my lord, are only confined to the question referred whether there can be a sub-classification or not.
Right.
And sub-classification as a concept was bothering your lordships, my lord, and there are some judgments which reflect that. Lord, please see page, Lord, 1. It starts with, my lords, the Chief Justice recently said, my lord, Champakam, my lord, I am not going into that, my lord. Thereafter comes Balaji. Balaji says that this is an exception to 15 and 16(1), and thereafter, which is changed in M.N. Thomas, my lord, which says that it's not an exception, it's an equality thing. Lord, thereafter, your lordships may kindly come to M. Nagaraj, my lord, which is at page 3. In M. Nagaraj, in my respectful submission, this question, my lord, started bothering your lordships, whether there needs to be some rationing so that the real beneficiary gets the benefit. Lord, please come to para 19, para 10. Thereafter, the judgment in Nagaraj was referred to a 5-judge bench to examine the correctness on 2 counts. Lord, first, your lordships can skip B. Second, being whether the concept of creamy layer can be made applicable to the scheduled caste and scheduled tribes. So those who are taking the majority of the benefits and depriving the more backward, should that concept come in or not, my lord? Lord, thereafter came, my lord, Jarnail Singh. Please come to page 12. And I have quoted, my lord, the relevant part. Para 12, my lord, I'm sorry, page 4, para 12. The judgment in Jarnail Singh refers to the broader object of amelioration of backward classes and clarifies that this cannot be achieved if only the creamy layer within that class bag all coveted jobs in the public sector and perpetuate themselves, leaving the rest of the class as backward as they always were. Lord, thereafter comes, my lord, Jaisri, Lord, recent judgment, my lord, Maratha reservation judgment, my lord, where, my lord, your lordships have saying that, have, my lord, reiterated that constitution is always an evolving document, and therefore we will have to answer to the needs of the hour. My lord, I am just placing it for your lordships consideration. I am not reading it, my lord, because it gives a broader perspective how your lordships would view a constitutional provision which is, my lord, for the betterment of the backward classes. Lord, then, my lord, I have, though that's not the question referred, Lord, just by way of an abundant caution, I have, my lord, at page 5, given finality of Article 341, which remain unaffected, my lord. Lord, even if your lordships were to take the view that subclassification is a permissible mode, my lord, that also would be as per the same constitutional route as prescribed. The state would recommend to the president, then thereafter it will go to the parliament, and parliament will decide whether to put it in the schedule or not, my lord. That's not the question, but by way of abundant caution, my lord, I have placed it for your lordship.
According to you, sub-classification will have to be done only by the parliament.
Yes, my lord. No, my lord,
No,
it
can be done even by the
identification by the state.
by parliament.
Yes, my lord.
And-
What is happening
and
now?
Implementation by the states.
By the state again. What happens, my lord, now? One caste is identified as a scheduled caste. It's only identification by the state. It comes to the President of India, then goes to the Parliament, and thereafter, after parliamentary legislation, that caste is notified for that state as a scheduled caste, and thereafter implemented by that state. So, my lord, that is not the question, but by way of abundant caution, my lord, I have quoted, my lord, Basav Lingappa, that 341 is absolute, my lord, and state of Maharashtra versus Milind. Lord, I am not reading it because that's not the question my lords are, my lord, considering. But, my lord, now kindly come to page 11, my lords. Ashok Kumar Thakur, my lord, this is 2008, where almost, my lord, your lordships were bordering on this issue, which your lordships are, my lord, considering now. Para 6 and 9. Reservation is one of the many tools that are used to preserve and promote the essence of equality so that disadvantaged groups can be brought to the forefront of civil life. It is also the duty of the state to promote positive measures to remove barriers of inequality and enable diverse communities to enjoy the freedoms and share the benefits guaranteed. Lord, thereafter, please come to, my lord, M. Nagaraj, page, para 23, my lord, page 11. Para 48 is relevant, my lord, at the foot of that page. It is the equality in fact which has to be decided looking at the ground reality. Balancing comes in where the question concerns the extent of reservation. If the extent of reservation goes beyond cutoff point, then it results in reverse discrimination. Anti-discrimination legislation has a tendency of pushing towards de facto reservation. Therefore, a numerical benchmark is the surest immunity, etc., etc. Lord, please then come to N.M. Thomas. Lord, this is quoted in Jarnail Singh, para 124. A word of sociological caution. In light of the experience, here and elsewhere, the danger of reservation, it seems to me, is threefold. Now, I'm not arguing against the reservation. I'm just not flagging the sub-classification issue, because sometimes we are likely to be misunderstood intentionally or unintentionally. Its benefits, by and large, are snatched away by the top creamy layer of backward class, caste or class, thus keeping the weakest among the weak, always weak, and leaving the fortune layers to consume the whole cake. Yes. Your Lordships, my Lord, flagged this for the first time. Justice, my Lord, Justice Krishna Iyer, my Lord, flagged it, which is now followed by the recent judgment in my Lord Chelbro, Leela Prasad Rao versus State of Andhra Pradesh. My Lords would find it at page 13. Para 165, your Lordship gets one. In our, my Lords get them. Yes. In our opinion, it was rightly urged by Dr. Rajiv Dhawan that the government is required to revise the lists. It can be done presently without disturbing the percentage of reservation so that benefits trickle down to the needy and are not usurped by those classes who have come up after obtaining the benefit for the last 70 years or after their inclusion in the list. Lord, thereafter comes, not in point of time, Lord, in my chronology, our Chitra Lekha. This interpretation will carry out the intention of the Constitution expressed in the aforesaid articles. It helps the really backward classes instead of promoting the interest of individuals or groups who they belong to a particular caste, a majority whereof is socially and educationally backward, really belong to a class which is socially and educationally advanced. To illustrate, take a caste in a state which is numerically the largest therein. It may be that though a majority of the people in the caste are socially and educationally backward, an effective minority may be socially and educationally far more advanced than another small subcaste, the total number of which is far less than the minority. If we interpret the expression classes or castes, the object of the Constitution will be frustrated and the people who do not deserve any advantageous aid may get it to the exclusion of those who really deserve. This anomaly will not arise if without equating caste with caste, etc., etc. Your Lordships, my Lord, then come to, my Lord, it was, this Vasant Kumar was read by, my Lord, the learned AG. My Lord, I am not therefore repeating. My Lord, on page 15, I have given, my Lord, my propositions, my Lord. There are 4 propositions. I am not, my Lord, going to read. I am just placing it for your Lordship's consideration. This is again, my Lord, at the cost of repetition, only to answer the constitutional question whether subclassification is constitutionally permissible, but not against reservation in any form.
Thank you, Mr.
Lord, Mr. Agarwal is appearing for Chandigarh administration, but he may be given some time. Lord, maybe after.
Should we hear Mr. Nafde right after lunch?
I will start after lunch.
After lunch, because we're almost at the stroke of 1.
Very well. I'll be
We
very.
had actually planned to complete this side by 1, so we'll.
I'm also,
that sense, eating into the time of the others.
I'm also there minutes. I may take 5 minutes. I'm also there.
Census for Haryana have to be submitted. Only 5 cents. After Tamil Nadu.
We'll hear Mr. Nafde right now.
At 2 o'clock we start.
Grateful to all.